Good evening, members. I'm sorry we didn't have class. We didn't have class last Friday because of a few technical errors. Today, we are beginning off with law of contract. Reason being, contract stems into partnership and agency. So agency, employment, sale of goods, torts, we run through that. That is why I felt we'll begin off with contract first before I engage you into these other areas. Bear with me, you might not receive a good reception the other side. There might be something that will be making noise. Yes, I'm not in my official position because I'd moved out, but because I had to make sure that I had to teach. So please, just bear with a few things that don't make sense. I know anybody will feel this is not something. But as we proceed, let's go slow. We're studying something that we go through every day. All of us meet the things every day. At times, people never know that whatever we're doing are contracts. But the truth is they are contracts. So please, I've told you at times the noise, bear with me, but it's within a flash, it will be off. Let me try to talk to them because I'd gone for burial somewhere and I had to request space for where to teach from. Not because this is what I do as a person. I know in your reception it is not very friendly. But please bear with me. Let's go slow until we finish this. I know by next 30 minutes, it will be off. I'm trying to will some a few things, but in the next 30 minutes, it will be off. So, we're beginning off with the law of contract. The law of contract. The question is, what is a contract? What is a contract? I know most of us enter into some of the things, undertaking, and we never know that some of the things are contracts. So what is a contract? A contract is a legally binding agreement made between two or more parties having contractual capacity. Now that is where the game begins from. Two or more parties having contractual capacity. We're discussing this, we're discussing contract, but I want you to know one simple thing, that even marriage is a contract. So we shall go slow. That some things at times have their own problems, but we must know how the law runs to guide us out of this. It is saying it is a legally binding agreement. When they say legally binding, it means that in any mistake that one party has breached the contract, you can be sued. you can be sued. When they say two or more parties, yes, a contract has to be between two parties or more parties. If it is more than one, it is a tripartite. If it is more than two, it is three, also it is tripartite. So when they say contractual capacity, now that is where the area we're going to discuss most. Contractual capacity. Not everybody has the capacity to enter into a contract. I know we're going to meet it as we get along. We're going to look at contractual capacity. So they're telling you it can either be oral, in writing, or inferred from the conduct of the parties. Oral, or in writing, or inferred from the conduct of the parties. Now, this is where the game begins. Oral, you know, you talk and everything is settled. In writing, you've written your things. Now, inferred from the conduct of the parties. People will always ask, what do they mean by inferred from the conduct of the parties? I know we're all human beings. The reason as why I told you I'm going to use the contract of marriage is very simple. Ask yourself, how does a marriage begin? You begin dating. After dating, you move on. Then you begin meeting the parents. Then all of a sudden, you get married. But the first question is, does any parent allow any child to begin dating below the age of 18? That is what they call contractual capacity. 2, inferred from the conduct of the parties. If it is inferred from the conduct of the parties, you've been dating. Is the dating resulting into marriage or dating? Or byakubaawo? Twesanyuseemu. Now that is where the game begins playing from. Inferred from the conduct of the parties. Because the first thing is you began dating. The first thing is you are above 18. Okay? You keep dating. The question is, does it yield to marriage or not? Because the next thing is we're going to look at the position where the contract is concluded. Inferred from the conduct of the parties. Let me give you an example. We date women. I go date a girl. Let me say she's at university, and she says, most of the ladies always tell you, let me think about it. The question is, thinking about what? Now that is the first step. Thinking about what? The next thing is, she has not told you, yes, it is either yes or no. But she has told you, let me think about it. But every time you invite her, she comes. When she comes, remember when she begins coming, you beginning inferring other thoughts. You just beginning to infer other thoughts. You invite her, you invite her to your place, please. That is an inference. It is an inference. Though her coming to your place does not automatically mean it is a yes, but it is an inference. So that is how the game begins. I know I'm going to explain this further. Then we begin on formation of a contract. Now, there are times the examiner sets this question in essay form, formation of a contract. How is a contract formed? How does it begin? The first is consensus ad idem. Now, most of the times, the examiner in your section A does not bring the word consensus ad idem. The examiner only brings the word consensus. The examiner only brings the word consensus, or at times only brings ad idem. But the truth is, it is always consensus. So consensus ad idem means the meeting of the minds. Parties must be aware of what they contract about. That you're not going to begin dating anybody that you've not discussed with. At times, you must discuss with the same person. That is when you know that, yes, I'm dating so and so. They've either said yes or no, but at least your minds, both of your minds have met. You've also known that somebody is dating me or somebody has interest in me. So when you begin dating, you began dating. After dating, the next step is an offer. Most of you will ask me what an offer is. Let's go through the normal positions before I explain what an offer is. These are conditions that the offerer is the person setting the offer, sets to the offeree. The offeree is the person either accepting the offer or not. And if accepted, then the contract is formed. Now, of recent, I've always had proposals. And some of these proposals are very interesting. You see men bowing down on one of their knees and asking, "Will you marry me?" That is an offer. Will you marry me? That is an offer. That is why I told you we're going to use the contract of marriage. Will you marry me? So the offer is there. You either say yes or no. If it is yes, well and good. If it's no, that is it. So they're telling you the offer may be directed to a particular person or a group of persons or to the entire world. So entire world. If it is the entire world, just give me a few minutes. Let me finish this. Still telling you something. The offer may be to a particular person, like a contract of marriage is specifically to a particular person. It's specifically to a particular person. That is why most offers are made to particular persons. But the offer at times comes to the entire world. In marriage, it is to a particular person because of one simple thing. You're not going to marry the entire world. You're marrying one particular person. But when you say that it is to a particular person, that is it. But the offer can be to a group of persons or to the entire world. For example, if you make the offer to somebody speaking, if you made the offer to other people, it will become very difficult. Let's look at the case of Donoghue versus Stevenson. Donoghue versus Stevenson. That case Donoghue versus Stevenson. Oh God. It's messing up with my notes. Okay. Carrill versus Carbolic Smoke Ball Company. Carrill versus Carbolic Smoke Ball Company. The defendants were manufacturers of a smoke ball. They advertised that whoever used their smoke ball and used it as directed and still caught flu would be compensated. I want you to give me one simple thing. When you look at when we're discussing the introduction of law, we had the plaintiff and the defendant.
Yes.
So you have to know the difference between the plaintiff and the defendant. So you must know that Carrill was the plaintiff, she's the one who sued first. The person they were suing was the smoke ball company. So they further stated that to show their sincerity, they had banked the money in a certain bank. Now, that statement, I know we're discussing contracts. That statement means there is consideration that they had banked the money in a certain bank. I know we're going to meet consideration down. The plaintiff bought the smoke ball, used it as directed, but still caught flu. Now the question is, when she asked for the compensation, the defendant denied, stating that there was no offer, and even if it was there was no acceptance. Now, I want you to be lawyers yourselves. Sit in the position of a magistrate or a judge. Was there a consideration? Was there a contract? Was the contract directed to a particular person? And was there acceptance? So let's go slow. It was held. Now, when you see it was held, the holding is the judgment. The holding is a judgment. It was held that there was a definite offer made to the entire world, and performance of the conditions amounted to acceptance. So, when she bought the smoke ball and used it as directed, it meant she had accepted. But remember, the advert was to the entire world. So whoever bought it, it was open. I don't know why this whole mess is happening. Anyway, bear with me, I'm not in my teaching area. That is why you're seeing this going on. Bear with me, not because I want it this way, but just bear with me. What is happening to my internet? I'll speak. Give me this microphone. Is anybody getting me? Fine. Sorry for this hiccup. I was still explaining one simple thing. Like I told you that a contract is legally binding. Oh, good. So let's move. I was looking at the case that now these guys address the whole thing to the entire world. To the entire world. Okay. Forgive me wherever I am, the connectivity is not very friendly. But I will still teach regardless of whatever it is. I was still telling you that when you look at that case, you have to look at two things. Was it legally binding? They said somebody believed in the offer. And it was to that person who believed in the offer. And she accepted to do whatever was in the offer. It wasn't oral, but it was in writing. Now you have to begin watching this. The reason as to why I had to begin off with the contract was because contract stems through most of the things that we are going to study. Most, take it or leave it. So be very, very careful. You must understand contract to understand business law. I remember when I was at close school, I was told one simple thing, that if you can never understand contract, you can never enter the kingdom of law. Because everything that we do are contracts. So at times we do the things and we think that this network is so bogus. This is a very hurting thing. Anyway, I cannot make noise. It's not me who makes. I'm not part of government. And some of the things, connectivity is not mine. I want you to watch. And this is where the examiner always sets a question from. The examiner will always set a question from here. The examiner never sets a question from all these other things. Now he comes here. When an offer is accepted, it makes it binding. While an invitation to treat is an offer, but not an invitation for offers, e.g., the bidding process, display of goods in the shop or supermarket. Now, I want to explain this. When they say an offer makes it binding, I'm still talking about marriage. When a person makes an offer, will you marry me? And then you say yes, and you marry any other person, please, they can sue you for breach of contract to marry. That is true. They will sue you for breach of contract to marry. There's a lady who was paid through her nose just because of breach of contract to marry. Oh God, why you give me this headache? Why are you giving me this headache? Anyway, I forgive you. I'll still tell you one simple thing, that when you make an offer, will you marry me? And she says yes, please, 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 that is an automatic contract. That is an automatic contract. The moment she marries any other person, it will become a very difficult thing. I know I've argued cases on this. I know, ladies, you forgive me, but this is a normal thing. A man will never spend money on you, and you think it is going to run that way. They have a way that they will always think this is supposed to be brought back. Now, Now, through the network is terrible because I'm not in the normal, my ordinary teaching area. True. I had to move off. The truth is, my boss has lost a mother, but I had to request some area, some teaching school to be in the area to teach. So don't bear with me. I'm teaching from a very, very long distance. I'm not teaching from a normal position. This is okay. So I was still telling you, ladies, please watch. Men, please watch. I think lawyers are going to be very difficult to you than normal. This is a normal game. But I've told you that marriage is a contract. You have to go slow. It's not one simple thing that you're going to go on for. The moment you accept the proposal, that means you formed a contract and you will be sued on that contract. Take it or leave it. You're going to be sued. I've told you there's a very, very recent example of a case. I wouldn't love to mention the parties, and I will never do that. But it's there. She conceded. Unfortunately, she was sued after 7 years. Please, I shall do the same. What I do, me as a person, what I do is your notes, whoever needs the notes. The truth is they're already there. The notes are already there. Now let's go slow. The notes are already there. The truth is I'm always giving them to your administrator. They're always there. Now, when you file for an invitation for BITS, it does not mean that there is a contract. They're just inviting you. There is always a question. What people always file is the difference between an invitation to treat and an offer. Now, an invitation to treat, this is the easiest example I'll give you. You men, when you move around where prostitutes are, or I call them ladies of the night. I never loved to call them prostitutes. They're ladies of the night. When you pass by, they will always call you Uncle Jangu. So when they begin calling you Jangu, it does not mean that is an offer. They're just inviting you. Now, when you get to them, that is when they begin telling you their offers. Short ya sente bweziti, gundi ya sente bweziti. Please, please. Temuntwala bubi. This is typically academic, and I'll always give you that examples just because I want you to understand some things. It's just like when you see goods displayed in a shop or supermarket. Please, those that displays do not mean it is an offer. It is just an invitation to treat. They just invite you to go there. It is not that they're telling you, please, this is sold at this. The same process in supermarkets. I know most of you have ever entered supermarkets. Supermarkets always have labels. But the moment you get to the counter, they will tell you, please, this is not the price. Now, that is where the game is. That is an invitation to treat. You can never sue that supermarket. Now, this is where the examiner always sets a question from. Always termination of an offer. The examiner always sets a question here for 5 marks. How is an offer terminated? So the offer may be terminated by death of either parties. When they say either parties, if I proposed and I died, and the other side, who's supposed to say yes, also dies, what happens? Let's look at the contract of marriage. I proposed, and me, the offerer, has died. The offeree is the person supposed to say yes. She has also died. So what happens? Is the offer still there? No. The next is rejection. Will you marry me? No. So the offer has been automatically terminated by the operation of the law. Now, this is where the game is. Operation of the law. The law says that Baganda of this clan can never marry themselves. Because you've been dating and you're proposing to marry yourselves, but the law has come up. Remember, I want you guys to be very cautious. We looked at the hierarchy of the court structure. Courts, you look at the LC courts, they have a right. They will pass ordinances. Abana bagundi ebekika kino tebalina kuwasa wano. So that is the operation of the law. Then they will tell you by lapse of time, and this is what I love most. By lapse of time. If it is lapse of time, I make a proposal, I make an offer to you. Will you marry me? You keep quiet. Then you begin doing other things. Then you keep quiet. I marry another person after 5 years. Then you begin asking me, why did you marry her? Please, it was lapse of time. The offer lapse with time. It lapse with time. Because I have a specific thing, 5 years is never time in time. Then we have a counter offer. Now, a counter offer is a very interesting thing. Counter offer. The easiest example I can give you for counter offer is by negotiating, bargaining. Every time you go somewhere, you begin bargaining. Nina sentence. I have this money. Now that is bargaining. Now when you begin bargaining, the original offerer has told you the price. When you give them a less price, please, they will change their mind. So automatically, the offer will be terminated. This shirt is 50,000 shillings. I'm giving you 20,000 shillings. And the guy says, please, if it's 20,000, leave. When they say leave, that is what it means. Because the offer has been terminated right away. So by revocation, before it is accepted, the revocation must be communicated to the offeree. The offeree is the person that you made the offer to. That is what they call the offeree. Now, the moment I make the offer, I expect you to say yes or no. That is why I'm telling you that time means a lot of things. So the moment I will tell you one simple thing, will I marry you or will you marry me? Or will you get married to me? Now you have a choice. You have a choice. The moment you keep quiet for a while, I have a right to change my mind right away. The moment I change my mind, I've revoked the offer. Then I will communicate you that I've changed my mind. Because you've not said yes, so it has been revoked. So the offer must be, revocation must be communicated to the offeree. The next is by frustration. I know frustration. I don't want this normal business of you guys thinking that you are frustrating. No. We're now looking at the legal position of frustration. I know frustration has other positions. Frustration is an unforeseeable position. The person wakes up, does this. I know we're going to discuss frustration at length, level down by, because we are finishing this today. Then we're going to look at frustration. then by bankruptcy or insanity of one of the parties. Now, bankruptcy or insanity of one of the parties has one simple thing that most people do not understand. Any bankrupt person or an insane person do not have contractual capacity. When we get back to the formation of the contract or the definition of contract, you must have contractual capacity. So any of these two people automatically do not have contractual capacity. So if I made an offer to you now and you became bankrupt or insane, automatically it is gone. So acceptance. This is when the offeree agrees to the conditions set out in the offer. The acceptance must be communicated to the offerer. Silence does not amount to acceptance. Now, this is what happens to my sisters. I make a move to you and you keep quiet. And you say, let me think about it. Or you do not tell me anything. I have a choice. That silence does not amount to acceptance. Because I'm in the middle. I do not know whether you said yes or no. Now, let's go to the next most examinable area, where the post is used as a mode of communication between the offerer and the offeree. Acceptance is deemed to have taken place at the place and the time of posting, which they call the postal rule. I know you're going to meet the question on postal rule in your section A, and most of the times, in your essay questions. At times, it will come in your section B, in the problem questions, because they're testing on one simple thing. It is either acceptance or the postal rule. The question is one that when I come in Bali and I send a letter to you, sending the offer, and when the offer gets to you, I say it is supposed to be replied. Let me say tomorrow at 5, 14th February, which might be, most of you call it, you call it Valentine's. To me, okay, it is normal business. It's Valentine's Day. You communicate to that person and tell him, please supply me this Valentine's either gifts tomorrow by 6 a.m. Now, the moment the person replies in the communication and says, yes, I'm going to supply you, please, that is already acceptance. That means there is a contract. There is a contract. Now, there are things that are very tricky. The world has changed. We either use WhatsApps or we use emails or anything. But when you send me the email and I respond at 4 a.m., 4 a.m. and say, yes, I'm going to supply, that means there's a contract. I've accepted. The moment you terminate, I'm going to sue you. The next position is consideration. And I want you guys to be very, very cautious. The consideration aspect is always examinable. It is genuinely examinable. The examiner either asks formation of a contract in its entirety. How is a contract formed? Or he will always ask the termination of an offer, or he will ask what is consideration and how is consideration? What are the rules that govern consideration? And at times when it comes as consideration, and most of the times it is always for 20 marks. So please be very, very cautious. Just give me a minute. Consideration. The examiner will always ask you a question that what is consideration and what makes consideration actionable, or what is consideration and what is consideration? What are the rules that govern consideration for 20 marks? And what, those are the questions that are set in essay questions for 20 marks. What is consideration and what are the rules that govern consideration for 20 marks? Like I told you that we're discussing a contract of marriage, and that is where the whole thing is going to run on contract. It is a contract of marriage. Remember, you began dating, you've made an offer, will you marry me? They have said yes. The next thing is, can we go and see the parents? Then when you go to see the parents, what are you going to discuss with parents? The next is consideration. Consideration is the bride price. That is what they call bride price. So let's go slow. Let's go slow on some of the things. You might not, some of the things you might look at them ordinarily. Now, let's go to what the rules that govern consideration. The rules that govern consideration. The first rule is consideration must not be passed. Consideration must not be passed. Parties must know how much is needed before or at the time of contracting. Anything that comes after the contract is concluded as past consideration. That is what they call consideration must not be passed. So I'll give you this position. Some of us, I will not say all of us, some of us use borders. We bought the border from point A to point B. When you get the border tells you that, okay, from taking you from here to there is this amount. And you say, it's okay, well, let's move. Then when you, as you're moving, the border begins telling you, this is too much. This is too much. Now, that is where the whole thing comes from. That as much as you do whatever you think, whatever comes after, whatever discussions we agreed upon is past consideration. Because at times you agree on the border with the border guy or the judge guy. In fact, we call them the judge guys. You tell the judge guy that you're taking me to this with this amount. He tells you, okay, it is 5,000. You go. Then all of a sudden he tells you, please, this place is too far. Give me more money. Now, whatever you've agreed on is what you're supposed to pay. What comes after that is past consideration. So let's go down to this case. It's one of the most of you guys look at some of these things and take them for granted. So in Roscola versus Thomas, the plaintiff bought a horse from the defendant. I believe you now know the plaintiff and the defendant. After the sale, watch after the sale. Anybody can know what underline the word after the sale. The defendant told the plaintiff that the horse was sound and free from vice. It later turned out that the horse was indeed vicious. So when they took them to court, this was the decision of court. It was held that the defendant's statement was made after the sale, so it amounted to past consideration, which is bad in law. You can never, if we have agreed on the position now, please, anything that you change and do anything. The reason is, I want to tell you one simple thing, that I brought this as contract because I know we all go through these things. And most of the times, this is what happens to us in life. So you must watch. So anything that happens to you is past consideration. I am not rushing this class today because of a few things, because I know it is one thing that happens to us. So after the sale, the defendant told the plaintiff that the horse was sound and free from vice. Later turned out it was vicious. It was held that the defendant's statement was made after the sale, so it amounted to past consideration, which is bad in law. The next rule. The next rule is consideration must be of value, though the value may not be necessarily be assessed. Consideration must be of value. When you get back to the first case that we had, that told Caril versus Carbolic Smokeball Company, they said in consideration would put this amount of money in the bank, and to show us society will deposit this money in the bank. Now that is consideration. That is the value. To show that they're genuine. Now that was consideration. So they're telling you it may not be necessarily be assessed. So because at times, it's not one simple thing that you can assess the amount that somebody has put there. We have a saying in Uganda or in Uganda that nkuyidemu omubiri. Okuyirawo omubiri means I've put my consideration. That is what they call consideration. Nze okuyirawo omubiri is consideration. Nzokuyirawo omubiri does not mean you know how much I'll put for that. That is one simple thing you must know. That is what they call consideration. So let's look at the case in Stilk versus Myrick. Stilk is the plaintiff. Myrick is the defendant. So a ship on a voyage got a problem. The captain convinced the crew members that whoever helped them handle the ship to its final destiny will be given an extra fee. An extra fee. The statement extra fee is consideration. The crew members allowed and helped the captain. He later failed to pay them, claiming that they had done that what was in the ordinary course of business. But remember, he has told them it is, I'll give you an extra fee. He has not discussed what the fee will be. But these guys have done the simple thing that they will tell you. I know we're going to discuss employment. Employment, when they tell you that this is overtime. Overtime, nobody will calculate what your overtime is. Nobody will calculate your overtime. So it becomes a little difficult. Will they assess your overtime at that time? So at times, as much as you put your time in, the overtime will be calculated later, because that is what they call consideration. So he later refused to pay them, claiming that they had done what was in the ordinary course of business. Because at times, most of the times, people think that what we are doing is in our ordinary course of business. And mostly employers I don't want to get there, but please, I know your employees, your employers. Some of these things do not make sense. I am not here to create a vision. It is specifically for academic purposes. It has nothing to do with these other things. So bear with me. It was held that they had done what was beyond their ordinary standard, and that was consideration. So be cautious. So the next thing is consideration must be sufficient, not adequate. Now, this is the most interesting thing. Consideration must be adequate, not sufficient. I've not put notes here, but I've just left one simple thing. The thing is, I want to explain this to you. And that explanation must be one simple thing that you must use. Because if I went for specificities, it will make a different call. The question is, if you bought soda downtown, well, I'm talking about downtown, thinking about people in Kampala. I'm using that as a yardstick. I know we all belong to different cities, but at times we buy soda somewhere. And basically, the ordinary soda, let me say the Coca-Cola, is 1,000 shillings. 1,000 shillings. Then you go to a hotel and they will give you the soda at 5,000 shillings. 5 or 10.
Yeah, this Steve and who? Riham.
Please, whoever is on, switch off your mic. So if it is 10,000 shillings, you bought a soda at 10,000 shillings, but where you know the ordinary price is 1,000 shillings. Now, when you go to a place and buy it at 10,000 shillings, are you going to begin suing them that why is it at this? Please bear, concede. There is what we call sufficiency. The question is, what is sufficient for you? If I look at Kampala now, you go downtown, the soda is 1,000 shillings. You buy it at 1,000 because that is what you want. Why do you want to go to Serena that are selling soda at 8,000 shillings and you begin making noise? Because Kampala downtown is 1,000. So it's sufficient for you. Don't make noise. Then the next is consideration must move from the promisee, though not necessarily to the promisor. If you go to a shop, you will buy something, but that money must move from you who is buying to the owner of the shop. But at times, the promisee is you who is paying. The promisor is a person in the shop. But at times, you get the shop and they will tell you, undi oguze ebintu bya sente meka, naye kati kwata sente zino ziwoli kankuwa ebintu byo. So the consideration has moved. That is the truth. It has moved. The money has moved. But you've not given it direct to the shop owner. But you've given somebody who is asking for change, and that balance or change has been given to him. That is what they mean. Then say contractual capacity. This is where the game begins now. The parties to the contract must have capacity to contract. If it is a person, he should be 18 years and above. And if it is a company, it must be duly incorporated. So for you to have contractual capacity, you must be above 18 years. And if it is a company, it must be duly incorporated. However, children or minors have capacity to contract on restricted terms. That means children also have capacity to contract, but on restricted terms. These contracts are voidable contracts. When they say they are voidable contracts, they are voidable in terms that they're valid You can enforce them or not enforce them, but they are valid. When they say voidable, voidable means they are valid. So when you're dealing with children, look at the contracts. There must be contracts of necessaries. So these may include clothes, shelter, etc., depending on the minor's state of living. Watch the minor's state of living. A child in Kololo and a child in Bududa. You ask yourself, is a pizza a necessary to any of the two? Look at their state of living. Because a pizza to a child in Kololo could be a necessary, but a pizza to a child in Bududa would be a luxury. So you have to look at their state of living. So it is the duty of the other party to prove that they were a necessity to the minor, and the minor really needed them. So you do not give anybody anything as a child. You have to monitor and say, is it true? Is the child coming from here or there? Will it make sense on that? So there's that case of Inman versus Nash. A tailor supplied 12 clothes and 12 waistcoats. 12 clothes and 12 waistcoats. Now, watch the waistcoat. Needed all those clothes. Was the waistcoats a necessity? Because you can wear anything without the waistcoats. You need the waistcoats. Now that is where the problem came from. Now we have the next is contracts of an education nature beneficial to the minor. Beneficial to the minor. In Godfrey versus Leslie, Freewin Publishers Limited, a minor gave his exclusive right to the publishers to publish his articles. Just like you can tell anybody, a minor tells, let me say, oh God, which publisher? I'm trying to avoid most of the publishers. Okay, let me say, you give your rights to New Vision to publish your articles. Now you've given the New Vision all your exclusive rights. So they're telling you, the minor later refused to pay. So when New Vision demands for the payment, he refused to pay. So he was taken to court. Now it was held that the contract was valid and enforceable since it was kickstarting the minor's career as a professional author. I want to ask you one simple thing. Most of you have always sent kids to present on TV stations. Now, when they are presenting on those TV stations, please, it is kickstarting the child's career in presentation, and that is a contract of an education nature. Those are simple things. Then the next is parties' contractual intention. Parties to the contract must intend that the contract shall be legally binding, because courts do not enforce illegal contracts. Now watch what they call contractual intention. If you do not have the intention to marry somebody, that is where the game begins from. If you went to church, the church will always ask, how old is he? If you went to an introduction, wa miaka mmeka, how old is he? Or what is the age of the woman? That is what they are looking at for contractual intention. Now, when we get back to what a contract is, it gives you the position of contractual intention. Now, we're going to discuss contracts. Now, you must know who is warranted to contract on the behalf of the company. If you're a husband in the home, who is supposed to contract? Is it the child or the father or the mother? So you have to ask, does this person have contractual capacity? So you have to watch some of those things. So terms of a contract. At times, the examiner always either advise down here for terms of a contract. At times, the examiner advise down here. So it is another grade of examination. So be very, very careful. These terms are either express or implied. The express terms are terms that are clearly written down in the contract, while implied terms are terms that are not clearly written down, but the parties intend that they should form part of the contract. At times, you might bring an askari at home, and the rules of the askari are, you're protecting my property from theft. Those are the express terms, protecting the terms from theft. But they're also implied that, please, if you saw my goods being burned, will you pick them or not? Just because I brought you for this? Now, the express are that I brought you to protect my terms, my items from being stealed. The express terms are that if you found my things being bad, will you pick them or not? That is why they're saying they are not clearly written down by the parties, but they intend that they should be part of the contract. They may be implied in law or in fact. So implied means it is hidden. So let's go slow. Under the Sale of Goods Act, it is implied that the goods are fit for the purpose and the owner has good title over them. Now, this is the most stupid thing. Anyway, it was for us when we were still at university that it is good for the purpose. Before they marry you, they will ask you, are you good for the purpose? Are you fit for the purpose? You might be good for the sex. But what they want is, will you give birth to their kids that is fit for the purpose? I am marrying you, but are you giving birth to my children? I told you guys, we are discussing contract. Do not attack me. It is specifically for academic purposes. Then they will tell you that it might be implied that the goods are fit for the purpose. When they say goods are fit for the purpose, men, fit for the purpose is sex. Even a woman, you never have a man who does not erect. If he erects, then he is fit for the purpose. That is the reason as why you had that relationship. So let's go down to they might be implied in law or in fact. So let's go to the side of the law. Under the Sale of Goods Act, it's implied that, okay, under the Employment Act, it is implied that the employee shall serve the employer faithfully. There is no way that it will be written down that you're going to serve your employer faithfully. It is just implied. Then under the law of agency, now, because it stems out of under the law of agency, it is implied that the agent that Under the law of agency, it is implied that the agent shall receive a commission brokerage contracts. Brokerage contracts. A broker is an agent. So that agent must receive a commission. You're not going to push ropes with the agent. That is the position. If he's a broker, he's an agent. Under all costs, he must get a commission. We have innominate terms, also refers as intermediary terms. Remember, these are what we call implied terms. Now, when they say innominate terms, they are called intermediary terms. There are terms that are supposed to be fulfilled before a contract is concluded. For example, I told you I avoid politics in most of the things, but at times I always give political examples. I'll give you the late Abiriga was typically known as a typical NRM guy. So if he tells you that I want to buy your house, now the moment he buys your house, he will tell you your house is green. Then you tell him, please. He will tell you, turn the house yellow because I'm a movement guy, turn it yellow. So the moment it is yellow, that condition of him telling you that please paint it yellow becomes an intermediary term. The moment he does not buy it, you sue him. You sue him. Then we have warranties and conditions. This question always appears in your section A. They will always ask you, what is the difference between a warranty or even essay question? What is the difference between a warranty and a condition? So a warranty is a minor term of a contract and breach of which does not liquidate the contract, but pays damages. But a condition is a major term of a contract and breach of which liquidates the contract. If you went to buy a car and you went to buy the car and they gave you the car without an engine, will you take the car? Automatically, no, because the car runs on an engine, because that is a major term. It's a major part of the contract. So at that level, you refuse and you terminate the contract. But if they gave you the car without a side mirror, one side mirror, one side mirror, but everything is normal, automatically the loss of the side mirror is a warranty. So you cannot, it is minor, you cannot terminate the contract. The contract stands. But if you're paying, you're going to pay less by that. There's privity of contract, and there is always a question on this. There is always a question on this. So please be very, very careful. Privity of contract. The doctrine of privity of contract is to the effect that a party who is not part of the contract cannot sue or be sued on that contract, or cannot benefit from that contract. Let me tell you one simple thing. If you married either a man or a man has married a wife, and you've all automatically gone through a contract of marriage, and somehow your sister or brother sees your either husband or wife with another person, can they sue for divorce? Automatically no, because that is privity of contract. It is privity of contract because they are not part of that contract at all. They are not part of that contract. So in Dunlop versus Selfridge, the plaintiff, a tire manufacturing company, entered into contract with Duke Company on the following terms. That Duke Company should impose on all its customers not to sell all the tires below the list price, and in consideration, Duke Company was given a discount. Remember, in consideration, it was given a discount. Selfridge, well aware of the contract between Duke Company and Dunlop and Duke Company, bought the tires from Duke Company and sold them below the list price. Remember, the contract had 3 people: the Duke Company, Selfridge, and Dunlop. The contract was between Dunlop and Duke Company. So Selfridge was an outsider who bought the tires from Duke Company. What? There was no contract between Dunlop and Selfridge. The contract was between Dunlop and Duke Company. So it was held that Dunlop could not sue Selfridge because there was no contract between them. Even if Selfridge knew the contract between Duke Company and Selfridge and the Dunlop, please, that contract was for them. So Dunlop would not sue Selfridge because the contract, they never had a contract with Selfridge. They only had the contract with Duke Company. Exemption clauses. Now, this is one thing that we see every day. These are clauses that are inserted in a, by the way, this is also very, very examinable, very great for your exams. So be very careful. Exemption or strong exclusion clauses. At times, the examiner will put exemption. At times, it will be exclusion clauses. These are clauses that are inserted in a contract that limit liability from a party that would have otherwise had the liability. To mention, these include parking at owner's risk. I know you all see these things. You're telling me parking at owner's risk, but whatever I'm parking on is your property. Why is it at my risk? Goods once sold are not returnable or not exchangeable. So for you to run away from that, you have to be very careful. So the examiner will always ask for an exemption clause to be effective. They will always bring it. They will always bring it in your section B, the problem questions. Those long stories. It's a story, but they bring it. So you must be very, very careful. For an exemption clause to be effective, it must be brought to the attention of the other party before or at the time of contracting. Before or at the time of contracting. It must not be ambiguous. It must be legible. And if displayed, it must be in a conspicuous place. Conspicuous means in a very open place. I know some of us have a few things, and this case is going to give us most of the things. In Ole Vassen Marlborough Hotels Limited, the plaintiff booked a room in the defendant's hotel. So Ole was the plaintiff. Marlborough Hotels were the defendants. So while in the room, she saw words in small print on the bathroom wall, reading, "All money and valuables should be left at the reception." So some of us have, we either have guest houses, inns, or any of these happening areas. So they're telling management shall not be held liable for any loss or damage. I believe all of us have entered either hotels, inns, or guest houses, and we've always met these words. So please watch. She later closed and left her valuables in the room. A thief broke in and stole her valuables. The hotel management maintained that there was an exemption clause to their liability. You enter the hotel and you get that statement in the hotel room. The hotel room that you paid for. It was held that the hotel management could not hide behind the exemption clause because they had not brought it to her attention before or at the time of contracting. That the contract was concluded when she paid for the room at the reception and she was not aware of the exemption clause. Now, this is one very interesting area. You bought a bus from where you are, and they will tell you, they'll put an exemption clause and say goods are carried at owner's risk. And somehow you reach and your goods are stolen. And when you ask, they tell you, look at the receipt. It says goods are carried at owner's risk. Was it brought to your attention before you're paying? That is where the examiner gets most students from. So what? Was it brought to the attention of the other party before the contract was made? Because the contract is made the time you're paying. So they say that the contract was concluded when she paid for the room at the reception and she was not aware of the exemption clause. So most of us do these things. Even if it had been stated that the plaintiff was a daily customer who ought to have known, would not stand, because every time she booked the room, she entered into a new contract with the hotel, so she was still not aware of the clause. So the next thing is vitiating factors of a contract. Vitiating factors of a contract. This is also another very examinable area. Vitiating factors of a contract. Now, the examiner at times asks you what are the vitiating factors of a contract, or he will always ask you what is misrepresentation and what amounts to misrepresentation. So please just bear with me, that we might run slightly further at least 9:30, but let's finish contract today. So the first vitiating factor, watch the vitiating factors: avoidable contracts. The avoidable contracts, they are not void contracts. The avoidable. When I say voidable, means the contract is allowed. So the first one is misrepresentation. I know most of us have done the same, and we've agreed, or we agree that we've done this. Most men have done this. You ladies, some of this has always happened to you. I'll insist on misrepresentation because the rest we shall run fast. Misrepresentation. This is a false statement of fact, not of opinion, presented and not of future, made by one party to the other, and the false statement induces the other party to enter into contract. For misrepresentation to be operative or actionable, the false statement must be a statement of fact, not of opinion. Not of opinion. That is what they call materiality. And the other party must have relied on the false statement to enter into contract, which is they call reliance. At one time, now I'm giving you live examples. When I was still at university, we used to have a lady who used to feel so sweet and felt nobody would date her. To her, she felt she came from a very high class. So somehow, some guy deceives her. After deceiving her, she fell in love. After falling in love, they dated and moved on. Unfortunately, this guy kept telling her that, please, I'm a businessman. But the truth is, he wasn't a businessman. His business was yali ayoza motoka. He was a kanabe. So that is where the game began. So when she realized she was in kanabe, she had a choice to either stay with the guy or move out. The truth is, we guys do our messes. I know we could discuss this longer, but there are a few things I avoid. So types of misrepresentation. Fraudulent misrepresentation. This is where a party makes a false statement knowing that the statement is false. He tells you it is false. 2 is negligent misrepresentation. This is where a party makes a false statement negligently and does not bother to establish its truth. For example, you have a function. Now you have a function and you ask somebody, is it going to rain today? And he says, tegenda kutonya. That person has a choice. Ask the meteorological center whether it will rain or not. But it tells you it will not rain and put the function in the gardens. Then when you put the function in the gardens, it rains. So you sue that person for negligent misrepresentation. Then we have innocent misrepresentation. Innocent misrepresentation. The party makes a false statement innocently believing it to be true. That you don't intend to deceive. what you're saying, you believe that it is true, but it turns out to be false. At one time, when I was at high school, my colleague made a statement. My battery is running low. He made a statement that Ainyeka Worida, the song, was sung by some group in Teso, but it wasn't. I never believed that it was from Afrigo band. And that is what it meant. They have mistake. This is why a party or both parties make a mistaken. This is where a party or both parties are mistaken as to the contents of the contract, and it can be res soir, where a party buys their own product, or res extincta, where the contract. Please turn off your mic. Where the contracting item has extinguished. Types of mistake. Common mistake. The times ask a question around here. Common mistake. Here, one party is mistaken as to the contents of the contract, and the other party is aware. You have to watch these statements. Mutual mistake. Here, both parties are mistaken as to the contents of the contract. Now, it is the third that makes the difference with the first. Unilateral mistake. Here, one party is mistaken as to the contents of the contract, and the other party is not aware. Remember, common, the other party is aware. With unilateral, the other party is not aware. Then we have to duress. We're now discussing vitiating factors. This is where a party to the contract is forced to sign a contract for fear of harm on his life, not property, e.g., pointing a gun at another with the intention of causing fear or loss of life or causing bodily harm, and the party signs a contract. So you under duress. For example, they force you to please sign this transfer form so that you can be released. That is strictly duress. It is duress. Then we have undue influence. This is where a party in a superior position uses their position to intimidate the party in an inferior position and forces them to enter into a contract. You are the boss, and you tell your junior, you sign that contract. And the junior will fear because you're the boss. And at the end of the day, they will sign the contract. They're signing the contract under undue influence. There is a question on this illegality. Illegality. Be very, very careful. Illegality. Now, these are referred to as void contracts. These are illegal contracts. This refers to illegal contracts that cannot be enforced by courts. The contracts that are also to as void contracts, and they include, and they will always ask you the types of illegal contracts. The first one is contract of an immoral base. Courts will not enforce contracts that promote immorality in society. So in Pierce versus Brooks, a prostitute hired a van and used it to look for her clients, and the driver was aware. She later failed to pay the owner of the van. It was held that the court could not enforce the contract because it was promoting immorality. Contract against public policy. And this is what we always do. Courts will not enforce contracts that promote corruption in society. So the moment you give corruption, you pay somebody, please, you never ask for that money, because that is a contract of corruption. Then contracts that impede that administration of justice. Contracts that are aimed at stifling prosecution are illegal and unenforceable, e.g., bribing a witness in court in a court matter. So you guys, witnesses, come to court and begin telling lies, oust the jurisdiction of court. Then watch. This is what it means. Every contract must provide for alternative dispute resolution, which is ADR, mediation, that we shall not go to court. That contract is illegal. You cannot work for MTN and work with Airtel at the same time. Neither can you work for UBS or NBS and work for NTV at the same time. They are trying to protect trade secrets. So that is reasonable. It is reasonable. then contracts made to commit a crime or a tort. Tort, we are going to meet it ahead. A tort is a civil wrong and a crime is an offense punishable by the state. At least we saw what a crime is when we were discussing criminal law. But a tort, we are going to meet it ahead. So be patient. So we're coming to discharge or termination of a contract. How does a contract come to an end? This is when a contract comes to an end, whether lawfully or unlawfully. The parties have either performed their obligations or failed. A contract may be discharged or terminated in the following ways. By performance. When you perform a contract, it is terminated. By mutual agreement, you agree that please, let's close it off. So that contract is automatically terminated. By rescission, rescission means that please, you've breached the contract, I'm not willing to move on. So you're rescinding the contract. That is what they call rescission. By insanity or bankruptcy of either parties. I told you when you become bankrupt or insane, you do not have contractual capacity. Then by operation of the law. The law says, please, we might be having a contract that I'm supposed to be selling you, let me say, Buvera. And Parliament passes a law that Buvera are not allowed. Automatically, that contract is terminated. Then by lapse of time. Lapse of time. You tell me to supply you flowers for Valentine's. Then I bring the flowers on Tuesday. Do you think that contract is there? Automatically, it has lapsed by time. Then by frustration. Frustration, this is an unforeseeable event that occurs touching the root of the contract and renders performance of the contract impossible. The event must not be self-induced. A contract becoming expensive to perform does not amount to frustration. A contract becoming expensive to perform does not amount to frustration. So it must be an unforeseeable event. For example, you call a musician to come and sing on your day. And unfortunately, you pay the musician. And unfortunately, that musician falls sick. Sickness is an unforeseeable event. It is touching the root of the contract. The contract is singing. So it renders performance of that contract impossible. So he cannot sing because he's on his sick bed. Then by breach. Breach means you fail to perform the contract. You failed. Then we have what we call remedies for breach of a contract. What are the solutions if you fail to perform your contract? What are the solutions? So the solutions are damages. Damage is money. You pay money. You fail to perform the contract, you have to compensate me. The other one is rescission. I terminate the contract right away. Terminate the contract. Then we have reinstitution integral. Remember, these are examinable areas. Reinstitution integral. Reinstitution integral means put me back in the state I were before your termination. Reinstitute me. Then we have an injunction. An injunction is a court order telling you, please stop your breach. Then we have quantum meruit. Quantum meruit means pay me for what I've done. Even if I've terminated, I've breached the contract. I've breached, but please, just pay me for whatever work I've done. And finally, specific performance, but only where the damages are not an adequate remedy. Now, this one I'm telling the ladies, never file for divorce if you still want your man. Always file for specific performance. Please come back home. Just come back home. Don't give me the money that you want. Come back and perform your duties as a man, because sex is not paid for. Because even if you give me the money, am I going to get the sex? No. All I want is you coming back home and perform your duties. So please, we've finished contract today. That is the end. I'm sorry I've tried to stretch you beyond the normal time, but that is the position. If there are any questions, please ask. I'm available. You can still ask them online, or you can get back to me in my inbox. Silence to me. Somebody. Silence to me means no questions. So let me wish you a good night.